Welcome to Illinois Law, a service of the Illinois State Bar Association. Today's program is another in a three-part series on cases out of the United States Supreme Court from the last term in the last year. And as usual, the court tackled serious problems that we read about in the newspaper every day. And we're going to talk about a few more of the cases. We already talked about others in another part of the series. We're going to take on some of the cases that the court had. And we put together a distinguished panel of guests, as we have in the past, to discuss the cases from the United States Supreme Court. And I'd like to introduce our panelists at this time. Professor Cecil Hunt is a associate professor of law at the John Marshall Law School. He's a graduate of Harvard College and a graduate of Boston College Law School. Our second panelist is Michelle Jochner. Michelle Jochner is a summa cum laude graduate from Mundelein College and a graduate also of DePaul University College of Law. And for the last several years, she has been a judicial law clerk with the Illinois Supreme Court, first with Justice Marianne McMorrow and currently with Justice Charles Freeman. Our third panelist is Judge Leonard Murray of the Circuit Court of Cook County. Judge Murray, who's been a judge since 2007, currently assigned a municipal division, is a graduate of St. Francis College and a 1974 graduate of Northwestern University College of Law. He's also currently chair of the Illinois Judicial Council. Thank you very much for joining us. And we have some more interesting cases from the United States Supreme Court. Judge Murray, why don't we start with you? There was a case, an Eighth Amendment case, involving juvenile offenders in the last term. Why don't you tell us what that case was about and what the court did with it?
Well, it's a very significant case. It's Graham versus Florida. And just briefly the facts, Graham was came into the criminal justice system at the age of 18, committed a robbery with a couple buddies. The state elected to try him as an adult. And as a result of that indictment against him, he pled guilty. He was sentenced to probation, a 3-year period of probation with the first year of incarceration. However, after roughly 6-7 months, Graham was released because he had been detained during the pre-trial stage. After Graham was released from prison, sometime thereafter he committed another offense, or at least was alleged to have committed another offense. And as a result of that interaction with the law enforcement, he was violated by his probation officer. And at the sentencing stage, Graham did not face the original judge in the case, but whether a different judge who did not preside over his juvenile proceedings, or at least the proceedings when he was 16 years old. And there were certain recommendations made after finding of guilt on the violation. And it's interesting because he was given a life sentence by this judge for this subsequent offense. His own lawyer recommended, I believe, something in the 4-year stage. There was a recommendation by the prosecutor that I think was maybe 10 years. And the Department of Corrections recommended 4 years. Graham filed a post-sentencing petition under Florida law because that was not adjudicated within the requisite time. I think it was 60 days. It was deemed denied without any actual review, which is a very interesting situation in and of itself. And because Florida had abolished its parole system at the time, Graham's only possibility of an early release would have been by executive clemency because there was no possibility of parole. So essentially, Graham was subject to a life sentence for a nonviolent offense as being under the age of 18.
Now, his original offense, he was how old when he committed the original?
16.
16 when he did the original
16.
offense. And then this violation for a nonviolent offense occurred when he was 18.
No, he was about 2 months shy of 18.
Oh,
so
not even 18.
He was still a minor.
All right. And then he got life for that offense.
Right.
And what did the U.S. Supreme Court do with it?
Well, the U.S. Supreme Court took the case, and ultimately the appeals court in Florida upheld the sentencing regime. The U.S. Supreme Court took the case and essentially said that a minor cannot be committed to a life sentence for a non-homicide offense. So that's the law in the land. Now, it was a 6-3 decision. The 3 dissenters were Thomas, Scalia, and Alito. And Thomas's opinion essentially said that the court here supplanted its own judgment about what is a proper sentencing regime for the states' rights issue, a federalism issue.
Well, what was the constitutional provision that the majority relied on in order to strike down the sentence and to reverse the sentence?
Right. Well, it is under the Eighth Amendment, of course, which talks about cruel and unusual punishment, and there are 2 analogies under the Eighth Amendment. One is a proportionality standard, and then the second is a classical approach, meaning that for certain offenses, certain punishment is just unconstitutional.
By proportionality, you mean that the penalty was way out of line for what the offense
fits the gravity of the offense.
Right. Okay.
But that was not the appeal here. Graham's appeal was essentially based on a classical approach that the punishment here is so severe that it's just purely unconstitutional without regard to whether or not it was proportionate to the actual offense that was took place.
And Judge, doesn't this build on the court's prior decision in Roper versus Simmons that minors as a class should not be eligible for a death sentence, and really reinforces the court's view, more recent view, that kids are different from adults when you're talking about criminal punishment?
Yes, I think that was the sense of the court. In fact, if you read Chief Justice Rogers' opinion, it was a concurring opinion. He didn't agree with the total rationale by the majority here, but essentially I think he relied on the notion that we should treat minors different
because they're not developed, their brains aren't as developed.
Right, the normal logic there.
Right.
And there was also some attack in the Thomas dissent on whether or not the court had really developed the philosophy that it had developed around the world in terms of how minors should be punished for offenses at this young stage. He really attacked that, saying there was no scientific basis for that, and therefore it was inappropriate for the court to go that far. Alito, in his dissent, suggested that, well, while it would be inappropriate, based on the majority's opinion, to give a minor a life sentence for a non-homicide offense, there was nothing to suggest he couldn't be sentenced to 50 years, which I thought was an interesting point he was trying to make, saying there may not be life, but I could give you 70 years, and that wouldn't violate the rationale of the Eighth Amendment as in this opinion.
Another thing that is in the headlines a lot are immigration issues and deportation issues, and the court weighed in on that in a couple of cases in the last term as well. Michelle Jochner, why don't you tell us what cases the court dealt with those issues on?
Well, you're absolutely right, John. Immigration issues are something that's at the forefront of the court's agenda. And in Padilla versus Kentucky, the court held that the defendant's right to effective assistance of counsel, which is guaranteed under the Sixth Amendment, requires criminal defense attorneys to provide affirmative, competent advice to a non-citizen defendant regarding the immigration consequences of a guilty plea that he may enter, including whether deportation may result from his plea of guilty. In this case, Jose Padilla was born in Honduras, but he was a lawful permanent resident of the United States for about 40 years. He had actually served in the U.S. Armed Forces in Vietnam, and he ran into trouble when he was arrested in his home state of Kentucky on charges that he distributed marijuana. He was a commercial truck driver, and about 1,000 pounds of marijuana were found in his truck. So, you know, nowadays a conviction for virtually any drug offense can result in deportation under federal law. And regardless of this, Padilla's counsel advised him to plead guilty and told him that he didn't need to worry about any consequences of deportation because he had been in the U.S. for 40 years, and that was long enough for him to have no worries about this. Well, unfortunately for Padilla, his attorney's advice was incorrect, and upon his conviction, the federal government began deportation proceedings. Padilla alleged then that but for the incorrect information that was given to him by his attorney, he would have insisted on going to trial and then perhaps would have been acquitted of the charges and not have pled guilty, knowing that deportation would have been the ultimate result of his plea of guilty. So he alleged that he was afforded ineffective assistance of counsel. And in a 7-2 decision authored by Justice Stevens, the court agreed with him.
Now, even though, again, there's always a constitutional principle involved, but even though this was an underlying case, was an immigration case or a deportation case, the constitutional principle that the court was focused on was the Sixth Amendment right to effective assistance of counsel.
Correct.
And the court has previously held for many years that effective assistance of counsel means not just having a lawyer, but having a lawyer whose advice meets a certain standard of effectiveness.
Absolutely,
Okay.
absolutely. And they found that here that the lawyer's advice did not, because it was incorrect advice.
Isn't this a little bit like, if you think about it, the Miranda case that Judge Murray had talked about a few minutes ago, in that the court is concerned about the information that the defendants get, their understanding about what's going on in their case. In one case, the understanding as to whether or not they were being questioned by a police officer, and in this case, their understanding as to what the consequences were of their pleading guilty. So I see a trend going here, even with the conservative majority of the court, in that they're very concerned about whether or not individual defendants and members of the bar are giving accurate information and people understand what they're being charged with.
Well, that's correct, because the court explicitly said that, under professional norms applicable to criminal defense attorneys, this assumes that they will correctly advise their clients not only as to criminal matters, but also as to the immigration consequences of a plea of guilty. And importantly, the court rejected the argument, which was advanced by the state here, that a defendant could prevail on such a claim only where counsel affirmatively misadvised the client. The court rejected this, saying such a holding would permit attorneys to remain silent on important matters, and this would result in an absolutely absurd result. It just would not make sense.
But in this case, the way you explained it to us earlier, it sounds like the lawyer did, in this case, affirmatively give wrong advice. Correct. But you're saying that the holding now which now, of course, applies to every state and every criminal case in the country. If you have an individual who might have deportation consequences as a result, particularly in a drug case where, as you said, it's almost automatic, that the lawyer is expected to advise them that. Correct. There's another case in the area of immigration that I want to talk about as well with Michelle, but we're going to take a break here for a minute. And then we'll get back to some more of the actions of the United States Supreme Court in the last term. This is Illinois Law, a service of the Illinois State Bar Association, and I'm your host, John Tice. We'll be back in a moment.